Okay, good afternoon, everyone. I think we're just going to give it another few seconds to let people join up and then we'll begin. Right. Well, thank you very much for coming this evening, or this late afternoon. The reason I wanted to address the issue of translated witness statements, it's arisen quite a lot in my own practice recently. That, for those that don't know, is personal injury, which is why I've mined that particular area for the cases I refer to, but the principles should be broadly applicable. Now, why does translation and interpretation matter? Well, it seems like a silly and obvious question, but it matters because evidence is quite important. Frequently, parties must seek to rely on evidence from a witness whose first language is not English. That requires a suitable written witness statement for that person to swear and rely upon, and courts will not consider a foreign language document unless they are translated. And a similar skepticism applies quite rightly to evidence that a court thinks should have been translated, but has not been or has not been properly. So I think it's important in those circumstances to remind us of the reasons for procedural regularity in relation to translation. I mean, first and foremost, it is only fair to the witness themselves that their own language is used. As if anything is wrong, they might lose their case or be in contempt. Of course, where a witness denies the truth of his own statement, it is not in the interests of justice to try and explain it away by I'm not really understanding the nature of his own words. And of course, it's vitally important that all the parties and the court understand the case that is being put to them as well, and that there is only one version of events, preventing any suggestion of evidence by ambush. Now, the real reason we all know is that evidential uncertainty risks almighty costs implications for whomever is responsible for it. And the responsibility, as I hope we shall see, usually lies at the feet of the solicitor rather than the lay client when issues arise in relation to translation. Put simply, we should be able to determine whether or not our clients speak sufficient English or not and act appropriately. So what I intend to do in this session is just remind us what those requirements are, look at how the courts have dealt with some perceived irregularities to date, and consider how one might fix some problems arise. If we still have some time, maybe have a look at some issues in relation to costs. Hopefully, you should all be able to see the slides in front of you. Please, someone text if you can't. But now, just to go through some common problems. So first, it should not be a problem identifying that your client speaks and writes no English. In that case, you need a translation for a statement, you need an interpreter for a trial, and you just have to comply with the technical requirements of a translated statement, and I'll come to those later. Now, it's one thing to learn enough of a language where you live in order to get by socially. It's quite another to get involved in legal proceedings in a language which is not your mother tongue and be cross-examined in court. So where it gets complicated is where your client speaks some English. Maybe he communicates well enough to you to give instructions, but you have to make a judgment call about whether it's enough English to appear at trial. And that's the real litmus test of whether a client has sufficient English, is whether he's going to be capable of being cross-examined on the disputed facts in court. And that can be a stressful experience where there is no language barrier. Now, these issues with language can arise in a variety of cases. For example, many languages are spoken in a firm, and the need for formal translation may not be deemed necessary or not necessarily recognized when you're getting by with the assistance of maybe informal in-house experience or translations, or when interactions with the clients are paper-based and the clients getting unknown help from friends and family at home, or when there's a liberal use of witness statement pro formas on common types of dispute that really need to be turned out quickly. Anyway, we can even get in the situation where the client themselves can request an interpreter, even though they've been providing their evidence in English to date for his convenience. And when considering such a request, one has to be mindful that the request itself, or the very presence of an interpreter, can be used as evidence that the statement is not in his own language. And for all intents and purposes, a good rule of thumb is if a client is not content to be cross-examined in English, his evidence should be formally translated in its entirety. Now, another problem may arise when the translation has been effective into a relevant language with regard to the statement, but other documents haven't been translated. So one might have exhibits attached to it or pleadings that bear the client's name in English, and those can often be fertile grounds for credibility issues to arise at trial. Now, the consequences of non-compliance should be pretty obvious to most practitioners. It was highlighted by Her Honour Judge Pearce, said practitioners need to be aware of the serious consequences that this may have for both their clients and themselves. A person can be committed to prison for a false statement made in a witness statement, which is why its accuracy is an important safeguard for everyone involved in civil justice. I mean, that safeguard is undermined significantly whenever a witness can be said to not understand something in their own statement. And the starting place is the Civil Procedure Rules Practice Direction 3223.2, which says that the court may refuse to admit evidence and may refuse to permit costs if it does not comply in relations to its form. Now, the first thing to notice is, so it's not automatically inadmissible if there are procedural discrepancies. But nonetheless, the consequences are pretty stark on being refused. The matter can be struck out. Evidence can be deemed inadmissible. Full or partial strikeout is possible. Limited weight can be placed on the evidence itself. There'll be inevitable cost consequences and ultimately potentially actions against one's own solicitors in negligence. So that's important to revisit something which should be familiar in any event, but we will revisit the actual requirements for translation under the CPR. Now, this is in Practice Direction 32 on evidence, and the starting point is 18.1. So in broad terms, the CPR changes introduced in 2020 addressed the issue of translated statements specifically and sought to regularize matters in order to put an end to the court's sort of ad hoc consideration over whether a client's understood English sufficiently as a sort of preliminary matter. So if one looks at 18.1, so a witness statement must, if practicable, be in the witness's own words. So arguments might be made occasionally about whether the witness statement being in the words of another, such as the solicitor, were justified and reasonable. But please note that there is no such qualification on the need for a witness statement to be in their own language. Now, what is meant by a witness's own language? Is it their birth language, their native language, their household language, their preferred language? We'll come back to that in relation to some of the cases, but these provisions were enacted principally against what was a common mischief of what I call translation in the wrong direction. Now, this is where a statement is taken in English, translated into the client's language, then signed and certified. Now, this statement will not be regarded as the client's evidence, but whomever drafted the statement in English. It is also rarely a solution to this obvious reversal of the right way to do things to then get the client simply to sign it as true in the version that he can read, because it is effectively asking them to confirm what is a leading document that somebody else has originated. Obviously, leading in evidence is not permitted in English, and it wouldn't be in another language. And such a statement would usually be regarded as substantially deficient and therefore requiring permission of the court to be relied upon. Now, the other most commonly the most frequent example of procedural irregularities within translation concerns in how a properly translated statement perhaps has been certified. And for that, we have to look at paragraph 23.2. So where a statement is in a foreign language, it must be translated, file the foreign language with the state with the court. Now, those two aren't particularly difficult, and it's this last element which causes problems. The translator must sign the original statement and must certify that translation is accurate. I've seen a multitude of problems with compliance with these issues, such as the certification being made by someone other than the translator, by it not being clear as to who the translator is on its face, by the translated statement, not the original statement being signed, and even sort of generic floating documents signed by the translation firm that the CPR has been complied with, that have a seemingly entirely independent existence from the translated document or the original. And the simple solution for that is just one must check. It is never a justification to blame the translation companies, no matter how much they may assert they are familiar with the CPR, for any failing to comply with it. And that's why one must generally find a translation firm that knows what they're doing and knows how to comply with it, and they are like gold dust. So before I look at some of the instances of the courts interpreting these rules themselves, just want to consider what other guidance has been prepared. Now, there has been some helpful guidance with regards to the High Courts. I should mention, of course, the small claims straight away, that these rules don't apply at all, because Part 32 is specifically disapplied in the small claims. There's really no guidance at all in terms of translation of witness statements, except what may be included in a particular court's general form of order. And in my experience, that generally amounts to make sure the client can read his own statement, and whatever happens, the court is not going to provide or pay for translation. So I hope, for access to justice's sake, that in a small claim requiring interpretation and translation, the costs of the same do not outweigh the value of the claim. So this is more in relation to the higher court, and specifically the business and property courts that have made specific and more detailed provision in relation to the interpretation of sections 18.1. The most useful of those guidance is the addition of Practice Direction 57 AC 3.3. This deals with it specifically. This does two things. Effectively, it says the solicitor with conduct of the trial has to sign a certificate of compliance confirming that the witness statement meets the requirements of the practice direction. That this doesn't necessarily ensure compliance, but it does preempt the direction costs might flow in a way that certainly focuses the mind and encourages it. And it also actually qualifies the words in 32.18 and defines what a witness's own language is, which is actually supremely helpful. It says that any language in which a witness is sufficiently fluent to give oral evidence in and is not limited to a witness's first or native language is their own language. Now, in hindsight, this further guidance is provided only in a High Court guide, which is not generally consulted for normal county court proceedings, is both unhelpful and bizarre, because it suggests a different threshold but might apply. But as a result of some of the cases being taken on appeal by the High Courts, it has become persuasive, if now authoritative, by having been cited in higher court cases. So one can regard that as a matter of pragmatism, having been incorporated, but it did lead to bizarre situations where counsel argued that one doesn't have to have that interpretation, because if the rule makers meant it to, it would have been included specifically. Now, let's have a look at some of those cases now. I'm going to cite just a couple. The first is Bahia and Sidhu in the High Court before Mrs. Justice Joanna Smith. Now, this was a case which concerned the dissolution of a partnership and the dispute over its assets. Now, Mr. Bahia relied on two untranslated witness statements in English. However, in his second statement, he acknowledged that English was not his first language, but he had some understanding of it. he usually communicated in a mixture of Punjabi and English, and it came to light that a Punjabi version of his second statement had been prepared, but not signed or filed. The assessment of the court in that case was that he could speak and understand simple English, but on getting stuck, he would switch to Punjabi. It's not an uncommon state of affairs for people with several languages. But the court also noted that he required an interpreter for the whole of his evidence, and even requested that sections of his second statement be translated to Punjabi before he was able to answer questions about it. It was also noted that at times he had difficulty in both English and Punjabi. Now, predictably in the circumstances, the representatives for the other side cited his lack of fluency at trial in combination with concessions made within his statement to say that he was in breach of all the relevant practice directions we've looked at and had failed to follow the Chancery Guide, and therefore no weight should be put on his evidence. However, and perhaps surprisingly at first glance, the judge found that there was no serious breach of the rules. Mr. Bahia's solicitors, it was commented, faced with a difficult decision over which language to use, and that their decision to do so in English could not be open to criticism, and the practice direction should be clearer as to the approach to be adopted in this situation. And that's probably what to highlight, because this does definitely seem to be something that turns on its own facts, because while the judgment is a useful assessment of which language a statement should be prepared in, where a witness speaks a mixture of two languages, it is quite unusual for a witness to speak a mixture of two languages without necessarily having a preference for one. And I think it was an important factor in the court coming to its decision that he genuinely seemed not to prefer one language over another. It was also important that his solicitors were aware of the issue, were in a difficult position, had made it clear throughout that this is the position they were in. It's probably not unrelated as well that this language issue was not raised until closing submissions after a 2-week-long trial. In particular, they referenced it being not practicable to do anything other than English because the nature of the hearing itself, being a partnership asset dispute, did not lend itself to a witness statement in Punjabi, because Punjabi did not have any of the equivalent for the English words that were used in the technical contractual substance of the claim. So they found that they literally couldn't really do anything else. So if we compare that to Correa and Williams, now this is before Mr. Justice Garston. Now this is a personal injury matter in which the claimant had been injured on his motorcycle. He was a Portuguese national who had lived in Britain for 20 years. He conceded he was not wholly fluent in English, and he required assistance from a translator in court proceedings. His witness statement had been prepared in only English, although when he had been communicating with his solicitors, he had given instructions in his solicitor, who was also fluent in Portuguese, and that statement was read back to him in Portuguese, and then the solicitor's actions were recorded in a statement of translation appended to the witness statement. Now, like the earlier case of Bahia, his issues with English were expressly admitted within his statement. However, the judge was still concerned that the way in which the witness statement had been drafted, given the claimant's first language was not English, was problematic. Because unlike Bahia, this was not a case of a client using a mixture of two languages, but very much of the evidence being that it had been not prepared in the claimant's language, which was Portuguese. So the judge ruled that the witness statement was not admissible, and consequently the claimant had no evidence to rely upon, and the case was dismissed. Other things mentioned in coming to that decision was, of course, the defendant was in full compliance with the rules. The claimant had known the defendant's case, but the defendant's understanding of the claimant's case had been obfuscated by the issues in relation to translation. So the absence of a Portuguese original statement was a substantive defect requiring court permission for reliance, and permission was not granted. Now, the High Court on appeal found that the trial judge had been absolutely entitled to refuse that permission and dismiss the case with this oft cited quote in cases when you are seeking to hold a translated statement to the very letter of the law, that it is an important discipline for litigants and their advisors that is not likely to be ignored. Effectively, the court said that the statement that the claimant was asking the court to rely on was an account of events drafted by the claimant's solicitor in a language which the claimant was not fluent. And put that way, it's fair enough, but it's important for the consideration of future cases go forward because it made comment on what to do where the defect in the witness statement is a defect of substance, i.e. that the judge being asked to exercise their power to give permission should consider the nature, seriousness and consequences of the deficiencies when deciding whether to exercise this power, i.e. the impact of it. Although from my perspective, it seems highly unlikely when fundamental comprehension is at issue as to how it cannot be critically affected in that way, unless, of course, one also arises with the fully compliant statements to rely upon in the alternative. The next case I want to look at is Asphal. It's another PI case, and this time liability had actually been admitted. The statement again had been prepared in English. The claimant spoke both English and Urdu, and the judge at trial raised the issue herself. She asked the claimant's counsel directly, "What is your client's own language?" He took instructions, and the answer was Urdu. The judge then referenced specifically the wording of 0.18.1 that and said it's not in his own language. The claimant's counsel then conceded that there was a serious breach of the CPR on its face, and it immediately put him on the wrong side of a late and unanticipated need for relief, which predictably was refused. So therefore, he had no evidence, he could not prove his claim, and the case was dismissed even though liability had been admitted. And what was the real problem here? The claimant spoke English. Whilst Urdu was his native language, his original language, the claimant also spoke English. There was no functional language barrier that had been the hallmark of other cases. So it went to appeal, and thankfully it was the subject of a successful appeal, in which the rather literal interpretation of the phrase own language to only mean native language, that meant the claimant was refused permission to rely upon it, it was noted would have been unnecessary if someone had pointed out the Chancery Rules in Practice Direction 57 that had qualified that phrase. So now it has been officially incorporated in any event. And the court observed, for those wishing to test whether or not their clients had sufficient English, that it was highly relevant that the claimant read, understood, conversed, and gave instructions in English. So as I placed there, so this is really a matter where legitimate judicial concerns about litigation in English between those who may not be sufficiently fluent to understand nuance was not intended to catch those who were actually functionally bilingual and entirely comfortable to be cross-examined in English. So it's very much a welcome common sense decision to undo the mischief of what was an overly literal interpretation in favor of access to justice that defendants in particular were utilizing to get matters struck out. Cynically, at first instance, the judge presented with an opportunity to deal with the matter summarily on a Friday afternoon and did so. Now, it still asks the right question that we should all be asking, that is fundamental to the decision, is what subjective assessment of the comfort levels of our own clients as witnesses we have to make in order to assess their ability to communicate. So that remains a good yardstick for reading, understanding, conversing in clear instructions. Now, in the more recent case of Beresford and Shah, again, it's quite an interesting decision itself on the illegality doctrine and contribution in PI case. In PI cases in general, this is a classic case of translation in the wrong direction. The witness statement was taken in English, translated into Urdu for the defendant to sign, contrary to CPR 32, which required those steps to be taken the other way around. And there was a finding the evidence was as a result substantively defective. And in that case, the court permitted the evidence to be relied upon, but it said it would fundamentally diminish the reliability to be placed on it. was held up as an application of the rule in Korea. And I suppose depending on the rest of the evidence, there's a significant question to be asked as to whether or not there is a functional difference between inadmissibility and reliance with significantly reduced weight. And I think it's telling in this case that there was a more contemporaneous statement given to the police that they could rely upon. So I think, mindful of the time, I'm going to bypass the issue of costs and just get to what we do about these things. Right. I know it seems rather obvious, but the first thing to do is, when faced with a client who either speaks insufficient English, or you don't know whether they speak insufficient English, that prevention is better than cure. Prevention is better than cure. Be in no doubt as to the level of English for trial, both spoken and written. Be alert to the warning signs that it might not be sufficient. Ask yourself, is a family member always present and talking for them? Is someone in the office translating for convenience? Are they monosyllabic in their responses? Is contact mostly by correspondence, where they could be getting assistance at home of which you are unaware? Are there any other signs or indications of a language barrier in other documents, medical reports, expert reports, correspondence? Of course, and at its most basic level, speak to the witness, undertake a conference with them, see how they deal with responses, and don't confuse heavily accented English with a lack of understanding, and certainly don't coach them in their evidence. Ask them open questions and have a conversation about a topic outside the confines of their case. Make them aware of interpretation and translation as an option, and don't forget to go through the written documents with them. If necessary, have a conference with counsel so they can conduct a mini cross-examination to test whether or not that English is good enough. But as referenced before, if they speak no English, that's easy, must be translation, and the translation requirements as set out in 3223. If some English, remember Asfel, do they read it? Do they understand it? Are they conversing comfortably with you in English? And have they provided clear instructions? And more to the point, if all that is something that they have done, have and keep an attendance note about it. Remember Korea. What is the impact of any potential failure? Consider the nature and seriousness and consequences of any future deficiencies in English. And if you do make that an assessment, have an attendance note saying that, so that you can then rely on that in the future if issues arise or the need for translation becomes more clear. So if one does proceed with an English statement, be clear within that statement itself what the client's level of English is, the manner in which the statement was taken, and the basis for the election in English. At the end of the day, better safe than sorry. If there's any doubt, get it translated, filed, and verified. So, assuming you went in English and you suddenly realize that that's no longer applicable, how do you give yourself the best chance of getting a successful application for permission? Well, again, you hold your hands up early, you apply for permission to rely on a translator and have documents translated as soon as possible. Late compliance is better than no compliance, and the earlier the issue is spotted, the more likely it is to be remedied. Do not leave it until trial. A fundamental translation problem discovered only at trial is usually fatal for the trial taking place that day, and in the new era of compliance and resource conservation, that may well prove fatal to the claim overall. So have compliant versions ready to go, so you can say, we can proceed today, let's just give my opponent more time to look at these extremely similar statements. Be upfront with the other side as well. Tell them that there is a language barrier and the reasons for your decision. That way, your application is more likely to succeed because you're taking away the other side's ability to raise it late as an issue and protecting yourself from a costs position. But having said that, don't wait for or rely on the other side's giving consent. These issues are often raised by the judges themselves. The next consideration would be, is relief from sanctions needed? Well, the application for permission to rely on a translator need not be an application for relief. The initial failure to translate is not going to trigger the need for relief. However, relief will still be required if ultimately the certified translated statement you want to rely on hasn't been filed with court ordered deadline for statements. What one cannot do is file a statement in English within the deadline and then provide a translation nearer the trial date, but after the deadline, and think that's compliant. It's not. One would need relief to rely on what would be considered a late statement. Again, the contents of that application, a few other bits and pieces. Again, I've said, you explain why it hasn't been translated to don't include as exhibit and reference assessments of the client's English in attendance note. Consider whether the litigation became more complex or functionally changed, triggering a need for translation throughout. Consider including whether or not it has been raised by the client themselves as a convenience, and cite CPR 1.12a, which says dealing with cases justly and at a proportionate cost includes, so far as practical, ensuring that the parties are on equal footing and ensuring that they can fully participate in proceedings and that parties and witnesses can give their best evidence. One emphasizes the vulnerability of a witness as a party if they do not have their own words. Now, I mean, finally, what is there to take out about this? It's largely, as I say, common sense. We do note that where foreign language issues arise, careful preparation of witness statements is necessary, and careful scrutiny of opposition parties' witness statements, if translated, is necessary and can often pay dividends. The parties relying on statements from witnesses whose own language may not be English should be conscious of the rules and the importance of complying with them, rather than taking a chance as to whether an opponent notices any defect is inclined to take the point. So know the rules and follow the rules. If you inherit somebody else's file, show that you did an early assessment of language. That could be a trigger point or an explanation for a reasonable late translation. Correa and Williams is regarded as establishing the principle that a witness statement must be in the witness's own language, not just their first language, and that a statement drafted by a solicitor in a non-witness fluent language, even if translated back for the witness to sign, breaches the rules and risks inadmissibility. Also be aware, of course, that many people are going to have been documented to try and take advantage of this by sitting on things and making late applications, and it will well be the case the courts will be alive to that situation, parties trying to achieve a tactical advantage by waiting until closer to the trial and then arguing a statement should be excluded. That's why it's important to document when these matters became apparent. The emphasis should always be on preventing unnecessary delays and court costs, and that goes both ways. And finally, just in relation to matters of personal injury matters where fundamental and dishonesty and fraud become live, it is not a defense in relation to those allegations to say that, well, my client doesn't speak English. Yes, more sophisticated parties could benefit from arguments saying they're not quite sufficient or not quite fluent in English to try and escape potential consequences of adverse findings made in their own language, i.e. there is something of a shield against which you can hide. However, judges are not impressed with the argument that clients can't be understood well enough to be regarded as dishonest. And remember that quox is equally disapplied when a matter is struck out. Okay, if there are any questions arising about the cost issues which I've skirted over, I'm happy to field them by email. But what I think I will end with is what regarded as a relatively recent cautionary tale for these issues, being the case of Rayner, Hughes and LVI. Now, this is a matter, this is a matter where there was a Turkish-speaking claimant who brought a claim for personal injury and £50,000 of credit hire. Her statement and pleadings were all signed by her, were all in English. And at trial, her own counsel confirmed quite simply at the first instance that she was entirely unable to read or understand English. Now, there is a particular kind of dread for an advocate who very quickly realizes that is the case in relation to a case that has been prepared throughout in English. Now, The solicitors insisted that the client had always had a good grasp of English and communicated with them in English from the first conference, but were fixed with a significant wasted costs order. They perhaps missed the sign that their daughter had always been present to help, but they tried to rely on the fact that the client herself never requested translation or raised a concern about an ability to be understood. One can imagine how well that went down with the court. It is, quite frankly, a cautionary tale that on matters so fundamental as comprehension and communication, it will rarely be the lay client who will be fixed with the cost consequences of any failure to follow these particular rules. Okay, I think I'm just going to end it there. If there are, as I said, any follow-up questions about either the contents of the note or about anything I may have said or anything arising from it, I'm happy to field those through Simon in the clerks, in which case I will just say thank you very much for joining us this afternoon.